Welcome, everyone. Thank you for joining us for our webinar on maintaining autonomy over your healthcare in later life. My name is Lillian Mehran, and I'm the Director of Outreach and Education for End of Life Choices New York. End of Life Choices New York is a nonprofit organization with a mission to expand end of life options, improve end of life care, and promote healthcare equity at the end of life. We provide educational programs such as this and resources. We advocate for patient rights and options and offer counseling to individuals and families. We are co-hosting this event with Pierre O'Connor and Strauss, LLC. Pierre O'Connor and Strauss, LLC offers individualized estate planning, trust and estate administration and litigation, and elder law services to private clients, their families, and family-owned businesses. The mission of Pierre O'Connor and Strauss is to empower their clients to achieve their goals, protect their families, and navigate through the complex problems encountered by each generation. We are offering this webinar as part of National Healthcare Decisions Day, which is on the 16th, but we like to celebrate it all week long. National Healthcare Decisions Day is an initiative to encourage people to express their wishes regarding healthcare and for providers and facilities to respect those wishes, whatever they may be. Along with other national, state, and community organizations, we're leading a massive effort to highlight the importance of advanced care planning. So what will we be discussing today? All of us face the possibility of incapacity in later life, and decisions about our healthcare may need to be made by a trusted family member or friend. Will your representative, called the healthcare agent, have the legal authority to speak for you? How will your healthcare agent know what your wishes are? How do you make sure your wishes as expressed by your agent will be honored by your physicians? If there are disagreements amongst your family regarding medical decisions, how will they be resolved? Does the law allow you to refuse medical treatment that may be life-sustaining? Today, we're joined with experts in the field of end-of-life care and law to discuss these and other issues concerning your rights and strategies to enforce those rights. At any point, feel free to enter a question into the Q&A box. We will be answering questions after the presentations. So without further ado, I will introduce our first speaker. David C. Leven is the Executive Director Emeritus and Senior Consultant for our organization, End of Life Choices New York. He was the Executive Director from 2002 until July 2016. A leading advocate for patients and an expert on advanced care planning, patient rights, palliative care, and end-of-life issues, David has played a key role in having legislation introduced and enacted in New York to improve pain, palliative, and end-of-life care, including the Palliative Care Information Act. David lectures frequently to diverse professional groups, students, and the general public, and has been a regular guest lecturer at College of New Rochelle School of Nursing, now Mercy College, and Fordham Graduate School of Social Service. He has also spoken at every New York City area law school. A graduate of the University of Rochester and Syracuse University College of Law, he is the recipient of numerous awards, including the Public Interest Law Award of the New York State Bar Association Public Interest Law Committee. David, I turn it over to you.
Thank you very much, Lillian. I appreciate the kind introduction. It's very nice to be here this afternoon. So I'm going to cover a lot of ground about advanced care planning. And just to tell you a little bit more about myself very briefly is that I've always worked for justice. Justice for Poor People was a legal services for the poor lawyer in Rochester for 10 years, justice for prisoners as the executive director of Prisoners Legal Services of New York for 20 years, and now justice for patients, having worked now for 20 years at End of Life Choices New York, seeking justice for patients, because what we're talking about today, and in so many different healthcare issues, particularly for people at the end of their lives, they are really health justice issues. So we have a 100% mortality rate in this country, and that's not likely to change in the near future. Despite the fact that we have all these wonderful teaching hospitals in the New York City area, where I imagine many of you today who are attending today are from. But for most of our recent history, dying was typically a pretty brief process. People died relatively quickly of heart attacks, strokes, cancer, what have you. But now things have changed, and they've changed pretty dramatically. And yet still, oftentimes the waning days of our lives are given over to treatments which are really not necessarily going to be helpful, but are keeping us alive because that's what doctors and nurses, for the most part, have been trained to do. They have been trained to treat and care people for their illnesses and diseases. And unless they know differently, they're going to keep people alive. So about 70% of those of us who are dying are going to die in a nursing home or in a hospital, not in our own homes, where most of us actually would prefer to die. So about 90% of us actually are now dying from chronic, progressive, incurable illnesses or diseases. People are living longer, but not necessarily better. And people are not necessarily dying better. In fact, many chronically ill, seriously ill people have a lot of different problems in terms of problems with poorly controlled symptoms, psychiatric disorders, concrete needs in the home, challenges in care coordination, etc. And we have another problem, and that is that doctors historically have been trained, again, to treat, and they've been very paternalistic to a very large extent. And so because they've been trained to treat and to cure illnesses and diseases, which they're very good at, they haven't necessarily been concerned about the suffering of their patients. And oftentimes, until recently again, patients didn't suffer much until they died. Now people can suffer for a very long time with an incurable illness or disease. We have another problem, and that is that in terms of end-of-life care in this country, it's not good. It's not good at all. According to a study by Duke University, it found that the United States ranked 43rd of 81 countries on how well healthcare centers provide for the physical and mental well-being of patients at the end of life. We need to improve a lot in terms of what we do with regard to end-of-life care in this country. So advanced care planning is extraordinarily important for people who are thinking about their future health care and what they would want and not want, what is important to them, what's not important, and what's not important to them in terms of care at the end of their lives particularly. But remember, you are in charge of your health care. Again, historically, doctors were very paternalistic, and they really made decisions about healthcare for patients. And it's only been since 1990 that it's been clear that patients have an absolute right throughout this country to make their own healthcare decisions and to make decisions with regard to any and all treatments, which can be started if you want them started or not. And even once they're started, you can have them stop. And it doesn't matter what kind of treatment it is. It can be life-sustaining treatments, such as dialysis or antibiotics or pacemaker, whatever might be keeping you alive. You can decide, as long as you have decision-making capacity, to stop those treatments at any time. Unfortunately, the vast majority of us are going to lose decision-making capacity near or at the end of our lives. And what that means is that someone else is going to have to make healthcare decisions for us. So it's really important to engage in the process of what we call advanced care planning. And it's really never too early to do this. People are able to do it when they're 18 or over. And in fact, all the leading cases involve very young women when it comes to end-of-life care decision-making. The Nancy Cruzan case, in which the Supreme Court of the United States decided, again in 1990, that her parents had the right to make healthcare decisions for her after she had been in a car accident and lost decision-making capacity. But it was not clear until then that parents could make decisions for their children. The Terri Schiavo case, which is now over 17 years old, 1985, where this poor woman was in a persistent vegetative state at 29 years of age. And the question was, well, what do we do in terms of life-sustaining treatment? Well, for many years, a lot of things were tried to get Nancy Schiavo back into having a reasonable quality of life. And yet all those efforts failed. But her loving parents understandably wanted to keep her alive, not knowing that she might not want to be kept alive under the circumstances in which she found herself. And this presented a terrible conflict between her parents and her husband, who had become a nurse to take care of her. And this conflict was only resolved by the courts because Terri had never appointed anyone to make healthcare decisions for her as her healthcare agent. So extremely important to go through this process and to think about these things. Of course, all of us want to have our healthcare wishes respected, right? But many people don't because no one knows what their wishes are. And as I said earlier, at the end of life, people generally aren't going to be able to make their own healthcare decisions. So when you go through this process, it's really making a gift to yourself and your loved ones because you can have, it's because then your loved ones know what your healthcare wishes are, what your values are, what your goals of care are, and conflicts can be avoided, which otherwise frequently arise. And let me just tell you, give you an example about conflicts, which can arise in the absence of having a healthcare proxy and appointing someone to be your healthcare agent. Let's assume that you are a 70-year-old person and you have a 95-year-old mother who is in a nursing home and has been there for the last 7 years. She's there because she has dementia. It's now advanced. She hasn't communicated for 5 years. She can't even feed herself any longer. She has to be hand-fed. And now she comes down with pneumonia. And the question is, do we treat her with antibiotics to cure the pneumonia? Well, let's say that you have a sibling who is loving like you are, has visited your mother in the nursing home frequently, just like you do. And so now what do we do? The doctor asks you and your sibling, what do we do about mom? Do we give her the antibiotics or not? Your loving sibling says, yeah, let's give her the antibiotics and get the pneumonia cured. Mom's been a fighter all of her life. Let's just keep her going. Let's just do that. And you think, geez, mom suffered so much for years now. She hasn't communicated. She has a terrible quality of life. Let's just give her good palliative care or hospice and let her go peacefully. Well, who's right? We don't know who's right because we don't know what mom's wishes were because mom never communicated her wishes to you or your sibling. She never appointed anybody to be her healthcare agent, and so you both are left at a loss as to what to do. Okay, so having said that, think about these things. It's important for you to consider what makes life meaningful and what does not, and making a statement about the balance between quality of life and quantity of life, and about under what conditions you would want life either extended or not. What matters to you? And remember though, when your healthcare agent is going to be making decisions for you, this is at a time when you no longer can make healthcare decisions for yourself. So you're not in great shape when it comes to your mental capacity. It means that you can't understand relative complex things about healthcare, but you're probably not in very good shape no matter what. So think about that because this is when decisions are going to be made for you with regard to life-sustaining treatments particularly, and as to whether or not you would want those treatments or not. Okay, so in engaging in the process of advanced care planning with a healthcare proxy and appointing someone to be your healthcare agent, you really need to complete the healthcare proxy document. The document itself is only 2 pages long, but the New York State Healthcare Proxy form is really very good. It provides a lot of guidance. It has 12 different statements that it makes in the first page about the form itself. And then it has a couple of pages about frequently asked questions. And then it has instructions for the completion of the healthcare proxy. So it's a pretty simple document to complete, but then there's a lot of guidance given in the New York State Healthcare Proxy form. So you're going to appoint someone to be your healthcare agent, and you also should be appointing, if possible, an alternate agent to make healthcare decisions for you if and when you lose decision-making capacity as determined by your primary care physician. You can also make decisions with regard to organ donations. And the one thing that you need that your healthcare agent, whoever you appoint, is going to have to know is what your wishes are with regard to artificial nutrition and hydration. And that can either be stated in the document itself, or you can state that your healthcare agent knows your wishes with regard to artificial nutrition and hydration. Now, many people don't want artificial nutrition and hydration, especially at a time after they've lost decision-making capacity. And it's been shown that for the most part, particularly for frail elderly adults and those who have dementia, that providing artificial nutrition and hydration really isn't going to improve or extend one's life. So again, here we are, this 2-page document, very simple. You need to have 2 witnesses, though, who are going to sign the document, neither of whom can be either your appointed agent or your alternate agent. And I should also mention that you can have more than one alternate agent, and some people do, but you can only have one person making healthcare decisions for you as your healthcare agent. That doesn't mean that there can't be discussion amongst family members, and in some cultures and some families, it's very important to have a group discussion. But in the end, the person who's going to make the decision and convey this decision to healthcare practitioners is going to be the healthcare agent. So there are important things to consider when choosing a healthcare agent. You want somebody that you're comfortable with and is also comfortable making decisions, even if their own wishes might be different than yours. Someone who understands what your wishes are. So you really need to have a very complex and comprehensive discussion with the person that you're thinking about appointing to be your healthcare agent. It should be someone who's not going to be too emotionally involved, someone who communicates and interacts well with people, and someone who's going to be a strong advocate for you, particularly with doctors and other healthcare providers. It also should be a person who can manage potential conflict between family members. So I've appointed my wife, because my wife has taught elder law for many, many years. She knows healthcare decision-making inside out. Her wishes are in alignment with mine, even though they don't have to be. And she's a very strong advocate. So she's the right person for me. I did appoint someone who I wrongfully appointed to be my alternate agent initially. This is the guy who's my age, who I think would be a strong advocate, but for the fact that he hadn't gone through the process of getting a healthcare proxy for himself. And so after a few years, I said, I think he's in death denial somehow and isn't so concerned about these issues. And so I appointed my mid-30s daughter after we had a discussion about things, and she seems to be a good alternate for me to have. So really important to consider a number of different things before you appoint someone to be your healthcare agent and alternate. And after you've gone through this process, and by the way, once you've have the healthcare proxy document, you should make a lot of different copies. My wife and I have had ours on our refrigerator. We have them on our cell phones. You want to make sure your agent has copies of the healthcare proxy document, as well as other close family members or anybody who might be involved in treating or caring for you. And that is true as well of your primary care physician and any specialists who might be involved in your care, particularly near or at the end of your lives. But you want to also have another conversation with your doctors, particularly when you start suffering from a serious or terminal illness, about what your diagnosis is, what conditions you have, your prognosis, the treatment options, what's available to you, how do they help, what are the side effects, and what your goals of care are. Things that you really need to consider very, very carefully. Because you really want to avoid conflicts, both with your healthcare agent, other family members, and healthcare practitioners. So having said that, if there are conflicts that do arise, by the way, this is something which hopefully can be settled between you after some discussion. If not, social workers can help resolve conflicts. If you or a loved one is in an institution, hospital, or nursing home, there's what's called ethics committees. And those committees can often be very helpful in resolving conflicts between family members, or between family members or you as a healthcare agent and healthcare practitioners. Now, there is a law in New York that was enacted in 2010 called the Family Healthcare Decisions Act for people who don't have anyone to appoint and have not appointed someone to be the healthcare agent. But it really should be avoided because it's a very complicated law. Conflicts can easily arise, and there is a hierarchy of those who are going to be designated to make healthcare decisions for you if and when you've lost decision-making capacity. It's not necessarily going to be a person who's going to know your wishes. They probably won't if you haven't appointed that person or someone else to be your healthcare agent. There are very difficult standards which have to be met in order for decisions to be made with regard to withholding or withdrawing life-sustaining treatments. And again, the person who's the surrogate may not be the best person to make healthcare decisions for you. Okay, so the second document I want to talk about is medical orders for life-sustaining treatment. In New York, we've had this law which has this document called Medical Orders for Life-Sustaining Treatment, or MOLST, since 2008. And it's really an alternate out-of-hospital do not resuscitate order if you want to complete this document. And you can say, of course, you do want to be resuscitated. This is all about getting your healthcare wishes respected, whatever they might be, and making informed decisions for yourself or for somebody else who's lost decision-making capacity. But the MOLST document can be completed for if you reside in a long-term care facility when you may or may not have decision-making capacity, in which case a healthcare agent can complete the document for you. Or you might die within a year. That's a good time to complete the document. Or you want to avoid or receive any or all life-sustaining treatment. If you don't have anybody to appoint as your healthcare agent, I think it's especially important at that point, especially when you're up there in years, to complete this document if your healthcare practitioner is willing to complete the document with you. And examples of serious health conditions when you might want to complete the document are and have a DNR order particularly are advanced stage cancer, congestive heart failure, chronic obstructive pulmonary disease, a dementia diagnosis, or frailty when near the end of life. Now, this document too is just 2 pages in terms of the way it needs to be completed, and it can be completed between yourself, as long as you have decision-making capacity, and your physician or nurse practitioner or physician assistant. This is the second page of the document. The first page just deals with CPR. And again, you can say you want to be resuscitated or you don't want to. And as you can see, the second page is somewhat similar to what might be included in a living will. And so it's pretty comprehensive and provides different checkoffs for treatment guidelines where you might want comfort measures only, or limited medical interventions, or no limitations on medical interventions. There are 3 different instructions for intubation and mechanical ventilation to help you breathe. There are checkoffs for future hospitalizations, and there are several different checkoffs for artificially administered fluids and nutrition. You can also put other instructions in the document as well. And I don't have that on the document that you're seeing on your screen. So it's a relatively simple document to complete, but it requires a discussion between you or your healthcare agent, if you don't have decision-making capacity, or surrogate, with the physician, nurse practitioner, or physician assistant. And it states your preferences with regard to what treatment you would want or not want. It's a signed medical order, and because it's a signed medical order, it's more likely to be respected. So there are a number of benefits of completing the MOLST document. I urge you to consider doing that, this particularly if you have a serious illness or disease, if you might die within a year, or if you just want to share your preferences with your healthcare professionals and have it as a signed medical order. It's supposed to be transferred with you from hospital to nursing home, back to your own home, etc. It's supposed to be reviewed periodically. And if you do complete it, you're going to want to look at it again and again periodically just to make sure that your wishes have not changed. Okay, so when it comes to getting the care and treatment that you want, and that's what this is all about, one of the most important types of care that you can get is palliative care. And palliative care has now been a specialized field just for the last 20 to 25 years or so. So there are a whole range of healthcare practitioners who have never been trained in palliative care and don't even necessarily know what it is, and don't necessarily know that their hospital or nursing home has a palliative care service. So palliative care is the specialized medical care for people with serious illnesses. And it's a type of care which focuses on symptoms and whatever else is bothering the patient, anxiety, depression, and so forth, to hopefully improve the quality of life both for the patient and family member. It's provided oftentimes by an interdisciplinary team of doctors, nurses, and other specialists who work with a patient's other doctors to provide what's really an extra layer of support. And it's important, and it's appropriate to be provided at any age and at any stage of a serious illness. And it's important to note that it can be provided together with curative care. It's not just end-of-life care, although it can also be end-of-life care. Now, it's provided in a range of different settings, and now pursuant to, and it addresses all these different things that I mentioned earlier. It can also even address legal and other difficult issues. Spiritual issues I did not mention. That's often important for people to consider as they're going through a very serious or terminal illness. And palliative care surveys show that the vast majority of people who have never heard of palliative care, 71%, according to a 2018 survey. But once people understand what palliative care is, most of them agree, the vast majority, 95%, that it's important for patients to know about it, to be educated about it, and to receive it if at all possible. I mean, who wouldn't want to receive palliative care if it was going to be helpful to them to improve their quality of life so that they get quality care, which they otherwise might not be getting, at least completely. But again, remember that too many doctors and nurse practitioners and others in the healthcare field don't know about palliative care. It may be something that you're going to have to advocate for yourself or for a loved one in order to ensure that palliative care is provided. So there are many barriers to palliative care right now, with doctors and other healthcare professionals not knowing about it, not knowing that it's provided at their hospital, thinking that there's no difference between palliative care and hospice. And even though hospice is a subset of palliative care, again, palliative care can be provided at any time during the course of a serious illness. There are too many doctors who aren't willing to refer their patients to the palliative care service. And if they do, they often provide the service very late in the game when the person may not benefit as much as they should if they were provided earlier palliative care. And when doctors learn about palliative care, then they understand it's important, and they're going to probably refer their patients to palliative care services once they understand what it's all about. New York has a couple of palliative care laws which are important to note. One is the Palliative Care Access Act, which actually now requires, since 2011, that hospitals, nursing homes, and home care agencies have policies and procedures in place to ensure that patients are going to receive appropriate information and counseling concerning palliative care. They're going to get pain management as appropriate and specialized pain management when that's appropriate. And information is going to be provided to those lawfully authorized to make healthcare decisions for patients who lack decision-making capacity. The other law in New York, which was also enacted in 2011, which I helped to initiate, requires that if and when you have a terminal illness or condition, your attending healthcare practitioner must offer to provide you with information and counseling regarding palliative care and end-of-life options which are appropriate to you, and also be offered other treatment options should you want to receive them. The information and counseling that must be offered includes but is not limited to the range of options appropriate to you, your prognosis, the risks and benefits of the various options, your legal rights to comprehensive pain and symptom management. And this information and counseling can be provided orally or in writing. Although frankly, I can't understand how it could possibly be provided in an effective way if it's only provided in writing. And again, if you are now terminally ill but lack decision-making capacity, the information and counseling is to be provided to your healthcare agent or surrogate. Now, again, it's very important to note that there are too many healthcare practitioners who are disregarding the Palliative Care Information Act. There is widespread disregard for it for a couple of different reasons. One is that doctors, like all of us, are human beings, and they have a very difficult time discussing death and dying issues, and so they avoid them. And so too oftentimes, even when they've made a terminal diagnosis, meaning that you are within a reasonable degree of medical certainty likely to die within 6 months, they are not going to have this required conversation with you so that you can make informed decisions for yourself until you're very close to death, within weeks or months. And that's really wrong, but that's the way it is. The second reason is that too oftentimes doctors want to continue to treat you because, again, that's what they've been trained to do, even if the treatments that they are providing to you aren't necessarily going to be beneficial and aren't necessarily going to extend your life or provide a better quality of life. So think about Palliative Care Information Act and what it entails if and when you or a loved one has a terminal illness, because you want to make sure that information and counseling is provided to you so that you can make informed decisions for yourself or for loved ones, or so that they can make these informed decisions and make decisions which are best for healthcare. Okay, we have another problem in this country, unfortunately, and really all over the world, and that is that there is too much unwanted care being provided to patients, and the wishes of patients are too often being ignored. And this really has to change. There was a survey that was conducted in 2014, which showed that about 1 in 4 Americans 50 or over or a family member had received excessive or unwanted medical care. About 25 million people. Again, totally unacceptable. And nearly 2/3 of those people said that they would withhold payments to healthcare providers who don't honor their end-of-life wishes, whatever they are. Many would take legal action. So we all expect, as we should be able to expect, that our healthcare practitioners are going to respect our end-of-life medical wishes. But again, too often they don't, even when they know that what our wishes are. So I'm just going to briefly mention this case. Dr. Gerald Greenberg, who's a retired periodontist, he had now advanced Alzheimer's when he's in a nursing home. He had an advanced directive, a living will. He also had a healthcare agent, an alternate, and then a MOLST was completed for him as well. While he was in the nursing home, he fell. He was found unconscious. He was diagnosed with life-threatening sepsis. The family agreed that he would never want to be given any type of care or treatment at this point to keep him alive. And yet, in fact, the doctor ordered antibiotics to be given to the patient for some days. The family attempted to intervene, but unsuccessfully. The patient then remained in the hospital for several weeks. Finally, his family had him transferred to a hospice where he died a few days later. But during that month period or so that he was in the hospital, he suffered, and his family members as well suffered. And it was so unfortunate because this was a man who did not want these treatments. Again, remember, he had advanced dementia. His family members didn't want him to get these treatments. And yet, despite the fact that his wishes were known, they were disregarded. So sometimes that may happen. And if it does happen to you, you need to be an advocate for yourself or for others. And you can get a lawyer or End of Life Choices New York involved, and we will try to help you. So I will tell you that what would happen with this case, a lawsuit was brought. Here's poor Dr. Greenberg, and initially it was dismissed by our lower trial court, which is the Supreme Court in New York State. And the judge held that there is no cause of action, no legitimate claim that can be brought in New York for wrongful life or wrongful living. Fortunately, just a couple of weeks ago, the appellate division of state Supreme Court reversed that decision unanimously, 5-0, and held that there was a cause of action, that damages could in fact be awarded for the pain and suffering that Dr. Greenberg endured during the last weeks of his life. So I'm going to stop here. My PowerPoint is available. Please feel free to contact me at any time by email or by phone. And also we have this wonderful free counseling service where our clinical director, Judy Schwartz, is available to provide counseling on any or all end-of-life issues that may arise where you might have questions or concerns about for yourself or for others. And Judy's unbelievably good at providing really exceptional counseling. So please do not hesitate to contact Judy if any questions or concerns arise. So thank you very much for your attention, and I look forward to answering your questions or responding to your comments after Peter is finished.
Thank you so much, David. Our next presenter is Peter Strauss. Peter J. Strauss practices trust and estate law and has a special interest in issues involving the rights of persons with respect to healthcare treatment at the end of life. He was one of the founders of the National Academy of Elder Law Attorneys, and in 2021, Best Lawyers named him New York City Elder Care Lawyer of the Year. And he's been included in the Best Lawyers in America 2007 to 2014, and in New York Super Lawyers Metro Edition 2007 to 2015. Peter is a distinguished adjunct professor of law at New York Law School and director of the Guardianship Clinic, which he founded in 2003. He has written articles for many professional publications, including the New York Law Journal. He's also a board member of End of Life Choices New York. Peter earned his JD from New York University School of Law and his bachelor's degree with honors from Bowdoin College. Peter, I'll turn it over to you and start your slides in just a moment.
Thank you, Lillian. And David, that was wonderful. I never cease to enhance my own knowledge. We think about the same issues, but I broaden my awareness of the complexities every time I share a platform with you. I have to say, everybody, welcome, and I'm happy to be part of this. I was somewhat amused by your first slide about the 100% mortality rate, which means, of course, we're all going to die. But you wouldn't know that from listening to the reporters on the nightly news or CNN or sitting at the family table when Americans say they lost their brother or so-and-so passed away. I tell my students that if they say that on an exam, there's an automatic 10% off. We do die. And I think these programs will work for people if they have to face it. They really need to face it. And that's what we try to do with these programs. And I'm honored to be on the board of End of Life Choices of New York. But I'm also honored to be a relatively small law firm that takes this seriously when we counsel clients, because not only am I doing this webinar today, but I think I repeat this webinar presentation every time I meet with a new client for, quote, estate planning. We're doing this kind of counseling because, as the title of the program says, this is taking control of your lives. And if we don't do this, if we don't take these steps and we don't understand the implications of these steps, we may have strangers running the end of our lives. We have court-appointed guardians who may not be a family member because maybe the children are fighting or there's divorces. or the spouse is ill. And we have strangers who not only don't have the time to deal with medical issues at the end of a person's life, but may know nothing about the wishes and may be lucky if there are advance directives to guide them. So with that as background, let me cover some of the things that you may have already touched on, and I'll do them very briefly, and maybe only if I have something to add. But the world is changing. Now, statistics can be boring, but in this case, they do form a bit of a background. So these are numbers from the 2010 census. I've done my research. The 2020 census numbers are not yet released in this kind of format, and I didn't have time to really spend a couple of weeks to dig them out. But you can assume these numbers are going to be a little bit higher, but they're going to be similar in terms of the growth rate. So just look at the fastest growing segment of American population is the over 85 cohort. In 2010, it was almost 6 million, and they're projecting in that census by 2050, 19 to 20 million Americans. The over 85, as the next slide will show, the next couple of slides, is the fastest growing area of the population. And obviously you'll see the next slide is about persons with disabilities. Americans are amazed that 1 out of 5 Americans have a disability, and that's not going to change. I'm assuming it's going to remain at that. So that's pretty remarkable. And people who are under 65 have significant healthcare problems as well. But the next slide, just very quickly, shows you that 50% of people over 85 need assistance in functioning, in dealing with the activities of daily living, not necessarily life-threatening illnesses, although at some point they will acquire that, but just functioning. And you all look around you, and I'm sure in your families you have that. And 75% of the prevalence of dementia is now caused, we believe, by the disease known as senile dementia of the Alzheimer's type, Alzheimer's disease. And the next slide, it just shows you, as you get older, the percentage of the population that is unable to function independently in the community. So these are problems that are going to be with us forever, growing, and the pressures in the hospital setting and in the home setting on what you want to do with the end of your life is just going to grow significantly. So that being said, I want to make one other comment that forms part of this. When Lyndon Johnson signed the Medicare law in 1965, I love this quote: "Every citizen will be able in his productive years when he's earning to insure himself against the ravages of illness and old age. No longer will illness crush and destroy the savings, et cetera, et cetera, et cetera." LBJ was a great politician, but he was a lousy prophet, because more seniors suffer from poverty as a result of the failure of Medicare to cover long-term chronic care, except in very limited situations, that this prophecy was wrong. And we need to address this. In the Biden Build Back Better law, which is not going to happen to the extent that we would like, if at all, there were some provisions for the first time that any president made to deal with the chronic care issue. And that will certainly, if true, relieve the economic hardships on middle-income Americans and make end of life significantly easier to the extent that you can, if in fact we provide some financial support other than the Medicaid program, which in New York is very generous, and that's a subject for another day. And in our office, we do a lot of Medicaid planning as well as counseling people who have high net worth. So this is just a little background that I think adds to your understanding of the issues we're talking about today. Obviously, what we've been talking about today is taking control and making the best of what is never a pleasant situation. I've touched on some of these points, but again, I want to emphasize it. And I want to make one point, Lily, next slide, please. Your advanced planning also has to deal with your property, your financial situation. We're only going to talk today about healthcare, but you need to be able to access or have your spouse or trusted family member access your finances so that you can be properly cared for at home. And that means a durable power of attorney. And we strongly recommend in our firm using trusts as the document that, one, manages your assets during your life, but also disposes of your assets when you die, as opposed to the quote will. With all kinds of problems today with wills and the surrogates court, but that's for another day. So a little bit of history, which I think will put some of David's comments in perspective. Nobody really knew much about whether you had rights with regard to the kind of medical care you wanted or you didn't want when you died. And the starting point for New York's law, and similarly around the country, was a decision written at the Supreme Court of the United States eventually. But when he wrote this decision, Justice Cardozo basically laid out a proposition that every human being of an adult human being who had sound mind, meaning had capacity, had a right to determine what shall be done with his body. And if a surgeon, a doctor, touches you without your consent, is committing an assault. What an amazing change in attitudes of people. And that led to a whole series of discussions. Next, please. It created this doctrine of informed consent that nobody could touch you, nobody could provide any medical treatment unless you agreed to it. But that morphed into a broader doctrine that not only was your consent required, but you had an absolute constitutional right to refuse treatment. So the story goes on, of course, as to how you get there. How can you exercise that right to refuse treatment, which you really didn't have in every state before the Cruzan case in 1990, which David mentioned earlier as one of the fundamental linchpins of our rights. So now we come to the next question. I think on the next slide, I'm right. If you have a right when you have capacity to refuse treatment, did that right extend to you if you lacked capacity? If you no longer could speak for yourself, if you could no longer formulate a wish or state what your wishes were? That was an even more radical concept. And the answer was, in this famous New Jersey Supreme Court case, New Jersey Supreme Court has always been relatively the pioneer in end of life and medical decision-making for consumers, you and me. And so in the Quinlan case, Karen Ann Quinlan, like Nancy Cruzan and Terri Schiavo, these were young women who were in comas or persistent vegetative states and were never going to get better. The New Jersey Supreme Court formulated this doctrine that a surrogate, someone could speak for you and exercise what is called substituted judgment. That doesn't mean that they are substituting their wishes or their goals or their concepts of what was right or wrong. Substituted judgment means that your trusted family member could express what they believe to be your wishes and that they are carrying out your wishes. Only then have the courts developed the fallback position, which is they could make decisions that were in your best interest. But that's not what is supposed to happen. This doctrine that you could have your wishes expressed even though you were incapacitated is that someone is standing in your shoes, someone is speaking for you, someone is advocating what they firmly believed with some evidence would have been your wish if they would have been able to speak. Now, New York has taken a different approach. New York never, until recently, went that far. In New York, you had to prove, next please, Lil, by clear and convincing evidence, a very high burden of proof, what the patient's wishes would have been. It's not just substituted judgment. It's a much higher standard of proof that the courts required if there was litigation about what to do in the hospital or home setting. And it took years, as the next slide will show us. It was only, I believe, yes, in 2010. It was a long time after the Quinlan case in New Jersey, which was 1976, that Governor Patterson, after 17 years of debate in New York, we passed essentially what was a substituted judgment law. And it took 20 years of negotiations and 17 years of debate in the legislature until we passed what David mentioned was the Family Healthcare Decision-Making Act. It allowed substituted judgment, and in a sense, it empowered healthcare agents to make healthcare decisions at the end of life. I've often had clients say to me, you know, if it was me, I couldn't turn off the respirator. Oh, no, I'm sorry, I got it wrong. Everyone's allowed one mistake. If it was me, I would do it in a minute, but I can't do it to my mother. I can't do it to my mother. I can't turn off her respirator and let her die. And I look them in the eye and I say, you're not doing it. You're an honest person. And you are telling the hospital staff, this is not your wish. This is your mother's wish. And they get it. The surrogate, the healthcare agent understands the difference. They're not making a decision based on what they think is best for mother, although that's certainly something they're thinking about. But they are doing their job. That is the responsibility of the healthcare agent, is to act according to the wishes of the person who appointed them. And I think that makes people feel a lot better because it is, in fact, the truth. So that's a little bit of history. I hope you understand this, and I hope it will help you. So a few more things about the healthcare proxy. We've got two documents we call the advanced directive. The first one is the healthcare proxy, and in a minute I'm going to talk about the living will because David spent a little bit of time on this, and I am sort of running out of time. We call the person who's going to make the decisions the agent. The maker is the principal. It's durable, as David mentioned, because it survives your incapacity. Otherwise, what good would it be? Note, we now talk about capacity rather than competency. We don't call people who can't make decisions incompetence. Capacity, I think, is a more appropriate term. But let's talk about who can make the healthcare proxy. I think that's important. People tend to think, this is one more slide over, Bill. I want to, I think we've already talked about this. Too many people assume that if you've been diagnosed with Alzheimer's disease, or you've had a few strokes, but you've recovered, and you seem confused, and you can't manage your financial affairs, that you may not be able to have a sufficient capacity to sign a healthcare proxy. Please don't make that assumption. I have a lot of clients who come in and say, I have to start a guardianship proceeding because my mother can't function anymore. She's incapacitated. And as we talk it through, we discover that that may not be true. The bar to sign a healthcare proxy may be pretty modest. Do you understand you're having difficulty making healthcare decisions? Do you seek assistance in doing that? Are you frightened that you couldn't decide and people will make decisions for you in the emergency room that you wouldn't want? If you understand all those things and there is a trusted person and there is a relationship between you and your life and that person's life, then I think you may well have the capacity to sign a healthcare proxy. So think about it, get legal advice, go call Judy Schwartz or David Leven and talk that out. But it's a terrible presumption on the part of not only lay people, but some physicians, because they don't really think this issue through. So I suggest that you think about that. Now, let's, in the remaining time we have, let's talk about the second advance directive, commonly called the living will. I never liked that term. We call the document in our office a healthcare declaration, because that's what it is. It's your declaration of the wishes about the kind of care and treatment you would want, or the kind of care and treatment you would like to forego at the end of life. And that document, the healthcare declaration, is one of the things that guides the decision-making of your healthcare agent. Now, we combine them in one document. In my last law firm, we kept them as two documents, but by vote of the partners of my little firm, we decided we would have it in one document. So it's there to see, the doctor sees it when she or he gets a copy of the healthcare proxy, healthcare declaration. And it's a very important document. Now, the next slide I want to just get to for a second. Look at this drafting language. What you don't see here is words that can cause nothing but trouble. I don't want any heroic measures. This document is effective when I am in a terminal condition or my death is imminent. Stick to something like this. You don't have to use these words, but you certainly can. It talks about my inability to engage in a meaningful life, mostly based on cognition. Now, you may say, well, it's not just cognition. I don't want any medical treatment if I can't enjoy a restaurant anymore. Sometimes my wife accuses me of having that standard. But it's very important not to use these words in bold at the bottom. And I'll bet if you go back and you look at your living will, if you have one, you're going to find that kind of terminology. It's troublesome and it can cause you issues. Sorry about the cough. Now, I want to touch on a growing and new issue. We know that in every state, if you meet the proper standards of the law in that state, you can refuse, or if started, can stop having artificial feeding. We're talking about nasal gastric tubes, pegs in the stomach, or sometimes even IV feeding, right? We've been discussing at end-of-life choices, and we've adopted this document in our law firm, although not every client has signed it, dealing with the issue of what happens if you are an advanced dementia patient, because I think that's mostly where it will arise, about receiving oral feeding and fluids when you are in a state of advanced dementia, but can still swallow. To many people, that's a very startling proposal. But it is being discussed both in medical and social work services. We've had many discussions about it in our organization. And we have developed, and my firm has adopted a slight variation of it, better suited to the law firm's practice than end-of-life choices, providing it on an educational basis to people. And we've attached to this PowerPoint outline, or you can obtain a copy. It's very thoughtful. It's very detailed. It gives a few options, but we can envision, and some people have signed it, that people, if they are at the state that they have no quality of life and really are not aware of their surroundings, or there's a variety of other situations that we posit would not want to have oral feeding. If someone asks whether it's legal, I can only say its validity has not been tested in the courts. We think a strong argument can be made that it is, and that it's ethically and morally appropriate in the appropriate case. But at this point, I can only leave that up to you, and read it and think about it, and we're happy to discuss it with you. Lillian, I think we may have, oh yes, David has covered this issue extensively, but this is a major issue in the hospitals in New York State. I don't know why my phone keeps ringing. My wife must be out walking the dog. So this is a little summary, basically what David has said, but I have to tell you, I have been involved in several of these cases. Many hospital, and the last few bullet points is, I did a forum a few years ago at New York Law School on end-of-life issues, and we published a special issue of the Law Review, and the reference to it is at the end of this PowerPoint. But it's something that we really need to be on guard about. David mentioned the Greenberg case, which I mentioned here also. There's the kinds of law that can happen. This matter of Zornow, which was in 2012, a judge refused to terminate the treatment of a patient in a hospital because he determined that there was lack of sufficient evidence to meet the clear and convincing evidence test, which no longer exists. But also he wrote in his opinion, Mrs. Zornow could not have wanted to terminate all treatment because she was a devout Catholic, as he was, and therefore her theology would have prevented her to reach that conclusion and belief. Now, I respect the right of theology and religious people, if that is what their theology is, to want all treatment. And there is a religious exception under the Family Healthcare Decision-Making Act to compelling treatment at the direction of an agent if a facility has made its policies known in advance of the admission or made known promptly to the representative who signs the admission papers, provided the facility has made those policies known ahead of the emergency or has transferred the patient to another facility. I had a case recently where a woman was in a persistent vegetative state. It happened during routine medical surgery for a non-serious illness. And she was in a religious facility which had a policy of not terminating treatment. I exchanged letters with them and they finally relented and did transfer the patient to another facility. But you need to make your wishes strongly known, and honoring patient choice is a serious problem. We've added some language to our living will portion of the combined proxy healthcare declaration, which indicates what the agent is to do if the facility refuses to honor the agent's legal directions. And we think it's quite effective. And we're finding that doctors would think twice. It includes things like challenging their licenses, regulatory agency complaints that the agent is directed to do. And then in the property power of attorney, we authorize the one who has control of the money to pay for the legal fees of the healthcare agent to bring litigation if necessary. So I think I'm at the end and we're not too much over. Lillian, what's next? Do I have any more slides?
I think you've got a few on medical aid in dying. Did you want to say anything about that before we stop sharing?
Well, maybe David and I will both do that. That does bring us to a big issue, which I didn't think we would have time for, but Medical aid in dying, why don't you go to the slide with the number of states that have it so people can see. Medical aid in dying is not legal in New York. Back up one, would you please? End of Life Choices was a participant in a lawsuit that was decided in 2017. We filed it in 2015. It's called Myers v. Schneiderman. And it challenged New York's law that makes it a misdemeanor to assist in a suicide. Now, we don't like the term assisted suicide. We think it's an inappropriate term. It's not what's happening. As David has pointed out many times, suicide is an act done by somebody who can live but doesn't want to live. And accepting medical assistance in terminating the life of a terminally ill person is assisting someone who wants to die, who wants to live, but is dying. They're very different situations. In this case, we made very strong, wonderful attorneys handle the case for these plaintiffs, for dying patients, for physicians, a nurse, and our organization. We went to the Court of Appeals. I attended the argument at the courthouse in Albany. We were all there. And we based it on New York State constitutional law because the issue had previously been lost before the Supreme Court of the United States. And we didn't think retrying those issues were going to work in the state court. They actually couldn't. And we were somewhat shocked when we lost. It was not decided by a full court because there were two judges short, I believe. Very strong dissenting opinion by Judge Jenny Rivera, pointing out how wrong the majority was. But that's it. David has been leading the fight in the legislature to enact legislation that would make it legal, as in how many states? Lillian, please move to the next slide. We've got 5, 10, 11 states and Montana by court decision. There's legislation pending in quite a few number of states, as shown on the next slide. And we expect more states to enact medical aid in dying. The laws are complicated. The number of cases is limited. And I'll leave you finally, because we really would like to take some questions. If you go to the next slide, just look at the statistics. No, back up. I think we may have passed it. That slide may have fell off. What the slide shows is that in Oregon, over 20 years, a relatively few number of people, one in relationship to the number of people who received terminal medication prescriptions from their physicians. There it is. From 1997, 24 years to 2021, 3,280 people obtained a prescription for life-ending medication, and only 2,159, or 66%, 90 persons roughly a year, ingested the medication and died. There's no slippery slope here. People are not clamoring for this, but it is a right which makes many people comfortable to know that if their suffering becomes intolerable, they have an out. And we think it's moral under the circumstances, ethical, and should be legal in most states. We understand it's controversial, but it is there. And finally, there were two other things that we don't have time to talk about, options that people are turning to. One is VSED, voluntarily stopping eating and drinking. And there's a lot of materials on our website about this. And Judy Schwartz has written a book with two other colleagues, brilliant scholars in the field. And a lot of senior people in states like New York, where you don't have medical aid in dying, are taking advantage of that, which is legal. And I think I'll leave you with one other thought about medical aid in dying. It's common practice in hospitals when people are suffering at the end of life to do what's known as terminal sedation. We provide such high doses of morphine or other drugs of a similar nature. So the patients are really unconscious. Are they alive? Technically, yes. If that is legal, if that is moral and justifiable in our society, a common practice in medicine today, is there truly a difference? Mechanically, yes, between that and medical aid in dying. And by the way, I wasn't always a proponent of this, but when I studied terminal sedation, it changed my mind about it. We tried to cover a lot. I hope we did. I hope you got something out of it. And let's see if we have people still around to ask questions.
Yes. Thank you so much, Peter. And actually what you just said about palliative sedation answered one of the questions we got. Another question we got regarding palliative care was if you could differentiate, you or David could differentiate palliative care versus hospice.
Well, palliative care can be provided at any time during the course of a serious illness. And it really doesn't even have to be serious if a person is suffering from symptoms such as pain or nausea or diarrhea, or whatever the case may be, or from anxiety or depression, or from spiritual issues that need to be or should be discussed. And it doesn't have to at all be provided near or at the end of life. And curative treatments can still be provided at the same time that palliative care is provided. Hospice is somewhat of a subset of palliative care, often provided by an interdisciplinary team, as is palliative care, but is only provided to people who have been determined to be terminally ill and are reasonably likely, with a reasonable degree of medical certainty, to die within 6 months. Hospice is often provided in the home, although it can be provided in hospitals or nursing homes or in even hospice facilities. Palliative care is generally provided in hospitals and nursing homes, although it too can be provided in the home. But again, the major difference is that palliative care can be provided at any time during the course of a serious illness, although not terminal, but it can be provided when a patient is terminal. But hospice can only be provided when a patient is terminally ill.
Thank you, David. And for everyone who has not yet asked a question, or if you have additional questions, feel free to put them in the Q&A box. Another question we got is, after completing advance directive, if you change your mind, for instance, if you would like to change who your healthcare agent is or alternate agent, can you do that, and what would the process look like?
They're totally revocable, amendable. Wishes can be changed. It's very common, particularly with the appointment of an agent. With a living will, it may be you want to tweak the language a little bit or add another thought or take out something. But with the healthcare proxy, unless if you have someone that you're not comfortable with, you can change it, and you should, because you don't want the person who is now misinformed about your wishes. And then if you're changing your agent because you think they have the wrong view of your views, you may want to then take a good hard look at your healthcare declaration. But yes, by the way, we have a very great healthcare proxy law in New York, but there is no statute in New York about living wills. And some of us debate about that, whether that's a good thing or a bad thing. My view is that it may be a good thing because there are so many terrible living wills out there, particularly documents that people pull from the internet that are filled with this, if I'm dying, I don't want any heroic measures. Well, is a heart transplant a heroic measure or a routine medical treatment today? Well, the answer 25 years ago may have been a heroic measure because it was pretty risky and untested. But today, my goodness, I mean, I had a doctor describe to me what an angiogram was and a stent in today's modern medicine. It sounded to me like you were going and getting a haircut. I mean, a little more complicated, but really, really routine. So language is very critical. And again, your agent is the most critical. It's not my daughter, the doctor, who should be your first choice. Her knowledge of medicine doesn't mean the decision that she would make is the one you want. Pick the one who is emotionally and psychologically prepared to carry out your wishes and be your advocate, not superimpose her or his own values for themselves on your life, and in this case, maybe death.
Just a couple of other points. One is that the most recently completed healthcare proxy is the one that's going to prevail, so that there might be other older healthcare proxies which are floating around, and also copies are valid. So you don't have to have an original in order for the healthcare proxy to be respected, and the healthcare agent's decisions under the healthcare proxy to be respected. The other point that I'd make is that if you spend any amount of time in another state during the course of a year, you might want to complete the healthcare proxy or whatever the document is called in that state. Oftentimes, it might be called a durable power of attorney for healthcare or healthcare proxy, because even though generally speaking there is reciprocity and states are required to respect the healthcare proxy from another state if the laws are somewhat comparable, doctors don't always understand that. And so they might see a healthcare proxy from New York when you're in Florida or California or Arizona, wherever you might be, and disregard it, saying that we don't respect the healthcare proxy from New York State. So good idea to complete the document in both states, as my parents did when they were spending half the time in New York and half the time in Florida near the end of their lives.
Two other very quick practical points. Your documents should be stored in the lawyer's computer system. So we copy every client's document. We copy the originals, we scan them. So if that client is in San Diego and winds up in a hospital, all somebody has to do is call the office and they will have a copy of that document in 5 minutes. You don't have to spend $250 a year to have them stored somewhere. And the other practical point is keep a lot of copies around and carry a copy in your wallet or in your suitcase. And you can also prepare a little wallet card with a mini copy of your healthcare proxy, not necessarily the whole document, but at least the proxy portion to have with you at all times.
Thank you both. And we have a follow-up question to that. To complete the healthcare proxy specifically, do you need to involve a lawyer?
You don't. I mean, the problem is that if you're going to pull something from the internet, it might be defective in some way. For example, in New York, the proxy needs to be witnessed by 2 people. There's a proposal to cut that back to 1. I'm not so sure that's critical. On powers of attorney, we just changed the law. Prior to June 13th of 21, powers of attorney did not need to be witnessed, just the gifting provision portion did. Now the entire power of attorney needs to be not only notarized, but witnessed. So if somebody goes to the internet and pulls down a form and isn't aware of that, and you think one that was published online in the summer of 2021 is okay, you may find up when you're selling your ownership of the Empire State Building at the closing of that transaction that it fails because the power of attorney wasn't witnessed. And by the way, powers of attorney in Florida have to be witnessed. So the answer is you can do it yourself, but there's more likely to be mistakes. Not that lawyers haven't been known to make mistakes, but we should certainly know that a power of attorney now needs to be witnessed.
And I put this in the chat. We have copies on our website of all advanced directives, including the healthcare proxy for New York. And I will be sending out a follow-up email to everyone, and I'll make sure that we include that. And we also are able to assist with we certainly don't do power of attorneys, but with healthcare proxies and other advanced directive forms, feel free to reach out to us with any questions. One other question we got was regarding concerns with guardianship. So if you have completed advanced directives and it is determined that you need a guardian, what does that mean in terms of who becomes the decision maker, and are there protections in place to make sure your wishes are honored?
Well, thank you. That's a fascinating question. I happen to be involved in a major guardianship battle right now on that very issue. Here's the reality. In order to appoint a guardian, you have to prove need for the guardianship. Need doesn't just mean medical need, that the alleged incapacitated person is truly incapacitated. If there are advanced directives, if I have a valid power of attorney, perhaps a trust to manage my assets, a healthcare proxy, and the living will, the healthcare declaration, why do I need a guardian? All of the functions of my life are handled by those advanced directives. So the other, and maybe most important, benefit of the documents that we are saying is taking control of your life, it's also protecting you from the appointment of a guardian. A person who may be a court-appointed representative, has no connection with your family, doesn't share your wishes or values, and may be stupid. So having advanced directives may be the most, or one of the most important values of your life. Good question, caller.
Another question we got. So you mentioned that there may be some misunderstanding about when someone has versus does not have capacity to complete advanced directives or modify. The question is regarding dementia. So if someone perhaps with an early diagnosis still has capacity, but then later wants to change their advanced directives, how is it determined if and when they are unable to, when they no longer have that capacity to do so?
Well, that's raising the ante. I mean, there is something called the global deterioration scale. I've also written an article about the capacity to sign a healthcare proxy. And my article arose out of a conference of lawyers back in 1995 on these very kinds of issues. And at that conference, there were some guidelines discussed, and I turned them into an article. It wasn't my original thinking, but I brought it into a succinct article. The global deterioration scale, developed by a doctor named Barry Reesberg, a psychiatrist who's been at NYU for years, describes 7 stages. And in each stage, there is a detailed description of the kinds of things the patient can do and can't do. So if a patient has a diagnosis of Alzheimer's disease, remember, Alzheimer's disease is not an on-off switch. It progresses over a period of 10 to 20 years through these various stages of 1 through 7. And if you're in stage 2 or stage 3, maybe in some cases in stage 4, if you can perform the tasks that I briefly mentioned before, you have difficulty understanding medical issues. You're not sure of what your understanding is correct or not, or you can't understand. And you really don't know enough. You're not comfortable making decisions. You acknowledge that you need help and that you choose somebody where there is a relationship with your life before dementia. not the Reverend Young Sung Moon. Then I would say during an interview that this person could execute a healthcare proxy. A living will is a little more complicated. There are more concepts in the living will because now you're getting into substance. You're not just appointing someone. So it may be that when you sign the healthcare proxy, the lawyer may conclude, or the doctor may conclude, or the social worker or care manager may conclude, yeah, I think Mrs. Smith can sign this, but 5 years later or 4 years later, we may come to a different conclusion. And it may not be the end of the world if in fact it's just, you haven't seen so-and-so for a long time.
Well, thank you both. I see that we're almost out of time. I want to just emphasize that we're still here even after the webinar is over to answer your questions. I will be including contact information in the follow-up email, so please feel free to reach out. Before we wrap up, Peter and David, do you have any final thoughts you'd like to share? David, maybe we'll start with you.
I really don't, except to the extent that I hope that any of you who have not gone through this process of having a discussion with loved ones or anyone that you might be interested in appointing to be your healthcare agent, that you will now take this seriously and do it now. Don't put it off. This is something which is too easy for people to put off, and something which too many people do for too long and sometimes never get back to it. And it's really never too early to plan. And so if you haven't gone through the process, please start now. Use us, Peter or me or Judy Schwartz to help guide you if you want or need help. But please do it, and to make sure that what we've said today is not going to just go down the drain, as it were. So thank you very much for your attention, and really appreciate the good questions and comments.
I would only say that this is not a process that you should necessarily be doing without consulting with your close family and friends, particularly your children. And coming up are some religious holidays, and it may be the only times that the family gets together. And it may sound inappropriate to be talking about these issues at happy family events, but if it's the only time you get to see your family, it's okay to have a discussion about these issues. Let them know what you want, because a lot of mistakes can be made that violate your wishes, your serious beliefs, if you don't make your family aware of what they are. And they may disagree and may try to talk you out of it. Mom, that's crazy. You would never want to do that. The answer is, yes, I do.
Thank you so much, both of you, for taking the time to speak with us and sharing your expertise. To everyone who's joining us, we'll be sending an email out probably tomorrow with links to the forms that we mentioned, our contact information, and also we should have the recording available soon. If not tomorrow, we'll follow up with a second email with that. So please keep an eye out for these emails. If you would like to learn more about advanced care planning and rights, I encourage you to check out our website and also our free comprehensive guide entitled A New Yorker's Guide to End-of-Life Planning Options and Rights. I'll make sure to include that in the email to you. We also recently released our End-of-Life Care Community Advocate Training, which is an online self-paced course for professionals who want to learn more about advanced care planning as well as other topics to better advocate for the communities that they serve. And I'll also be including the link to that in the email. So that's it. Thank you so much for joining us this afternoon, and I hope you enjoy the rest of your day. Bye for now.
Bye all.